So if you can understand my English, I would like to develop on the history of a matter of growing concern for international actuality, ransom insurances. In 1681, a legal text, the Ordinance Navy, recognized in France the validity of two insurances mechanisms related to ransom. Ransom, which is a price given for the liberation of a captive. The first mechanism is described in Article 9 set forth in your handout. This article provides that, in consideration of a premium, the insurer shall pay the ransom of the insured individual if he was taken prisoner. By such a mechanism, a person insures his own life as a free person. The risk which triggers the obligation of the insurer is the captivity of the insured individual. We will call this insurances contract freedom insurance. The second mechanism is described in Article 11 of the Ordinance set forth in your handout. This article provides that, in consideration of a premium, the insurer shall reimburse the person who paid the ransom of a third individual party if this third individual party is captured again or is killed during his way to come back and is thus unable to repay the price given for his ransom. By such a mechanism, an individual person can foresee a potential absence of reimbursement. The risk insured is the second captivity or the violent death of a third individual. We will call this mechanism repurchase insurance. Because these two articles are set around an Article 10 prohibiting insurances on the life of persons, the initial commentators of the ordinance have developed their views on this mechanism in coordination with the prohibition. So, in the first point, we will examine how the initial commentators of the ordinance in the 18th century have reacted to the transition caused by the legal recognition of ransom insurances and by the prohibition of insurances on the life of persons. By commentators will include all authors or legal authors of some authority who have commented all the article of the ordinance or who have presented the article 9, 10 and 11 in law treatises on insurances. In the second point, we will examine how the retrospective views considering the legal recognition of ransom insurances as a transition between inexistence or prohibition to legal recognition of modern life insurances. We will wonder if the initial commentator's view, developed in the first point, has been obstacles or promoters for modern life insurances. The 18th century authors provide more or less the same justifications for the prohibition of insurances on life. It's improper and contrary to public decency and accepted standard to put a price on human life. The life of individuals isn't to be traded. It may not be estimated or subject to mercantile speculation. Because of these elements, insurance on life would result in excess and deceits. Conversely, neither the ordinance nor the 18th century commentators define the notion of insurances on life of people. This arrangement may perhaps be understood in a wide fashion as being any insurance covering risk relating to the life of individual, accidents, illness, captivity. It may also be understood in a stricter fashion as being ensuring the risk of death or survival, or merely the risk of death. This notion can include insurance on a particular on his proper life, or merely contracts on a third-party individual life. the relation between freedom and repurchase insurance with insurance on life may differ depending on the elected view. In addition, in the text of the ordinance, the article on freedom insurance is set before the article on prohibition of insurance on life, whereas the article on repurchase insurance is set after with a kind of explicit textual link, the word néanmoins, nevertheless. Based on these elements, we shall review the views of the 18th century commentators successively on freedom and on repurchase insurance. Marville perceives that the arguments put forward to justify the prohibition of insurance on life could actually apply to invalidate the freedom insurance. He explains that this transition is authorized in favor of the Christian religion, which requires that Christians taken and dragged among Turks and other people of a religion adverse to ours shouldn't be left. These arguments may appear to lack substance, but we should note that this justification is neither economic or legal, but moral and religious. It's of the same nature than these given for the prohibition of insurances on life. Valin, Potier, and Emerigon don't deal with a possible relation between freedom insurance and insurance on life. In addition, Emerigon takes an extensive view of the wording on the Article 9 on freedom insurance. He appears to consider that the setting of elements mentioned in the Article 9, such as the price of the ransom, are not essential to the validity of the contract. He elaborates on the consequences of alternative situations, a pre-agreed and no pre-agreed figure of the ransom to be paid by the insurer. All the authors elaborate on the relation between repurchase insurance and the prohibition of insurance on life. For Marville, Potier, and Emerigon, repurchase insurance is no insurance on life because it doesn't insure life, but only the price paid for the repurchase. This view is more than a playing on words, or a simple limitation of the insurable amount of money. By paying the ransom of a captive, the payer becomes the creditor of the former captive for the price of the ransom. So when he subscribes a repurchase insurance, this payer-creditor insures something which should become his own property. By affirming that this contract insures the price of the ransom, the commentators bring closer repurchase insurance to insurance on goods, which are very common at the time. One commentator, Valin, takes a completely different view on the relationship between repurchase insurance and insurance on life. His view is that repurchase insurance is an insurance on life. According to him, repurchase insurance is an exception introduced by the ordinance to the general prohibition of insurances on life. He justifies this exception by a flat and finite statement. Let's only say that the legislator found this fair, and that's it. However, all the commentators particularly concentrate on an item of the repurchase insurance related indirectly to life. Indeed, the Article 11 provides that the natural death of the captive can't trigger the insurer's obligation. All the authors support this limitation. This standpoint is not surprising. Indeed, at that time, pursuant to the very notion of insurance, the event triggering the insurer's obligation must be a hazard related to the maritime transportation. Emerigon explains that because natural death is common to all mankind and not due to maritime transportation, such an occurrence is not an insurable risk. The mere uncertainty on the date of the natural death is not insurable. Marville, Potier, and Emerigon provides examples of natural death, which are therefore not insurable. Illness, apoplexy, stroke, suicide. These are only examples, and they are never provided as limitative. By using a fairly extensive notion of natural death, these authors restrict the scope of the repurchase insurance. We should note that all the foregoing elements don't completely exclude the event of the natural death from the repurchase insurance mechanism. Emerigon presents the event of the natural death as a compensation of the insurer risk. In case of such a death, as well in case of a safe return of the former captive, the insurer returns the insurer premium. In the course of the 19th century, an insurance mechanism called life insurance has been recognized in France. This notion covers two precise forms of insurance. The first one is that in consideration of a premium, an insurer pays an agreed amount if the insured individual is still alive at a certain date. Or, in consideration of a premium, the insurer pays an agreed amount of money to a third-party individual upon death of the insured person. Sometimes these two mechanisms are combined, and in any case, life insurance is perceived as a kind of contingency investment instrument. Retrospectively, the introduction of freedom and repurchase insurance is generally considered as a step in the transition process from inexistence or prohibition of life insurance to the legal acceptance of this arrangement. This is probably true. The recent chores developing the idea of such a transition, it's authors from 19th century to nowadays. They present the views of the initial commentators of the ordinance as an obstacle to the transition process. Certain authors take the extreme position that the prohibition of the Article 10 was absolute. So they present the justification of the initial commentators as a reflection and a support of this absolute view. Because of this link, both the legislative view and the doctrinal justification are presented as very poor and as obstacle to the development of life insurances. Of course, this approach runs up with some problem in the justification of the presence, of the legal presence of freedom and repurchase insurance. Other current authors develop a more articulate criticism on the contribution of the initial commentators to the transition. They consider that the initial commentators of the ordinance not only gave a ridiculous justification for the prohibition, but also misunderstood the scope of the prohibition. To this view, the prohibition was not aimed at any and all form of insurances on life, but merely at gambles, at a bet on individual life. The argument is that, at the time of the ordinance, no true life insurance existed. Because there can be no prohibition of a transaction which is actually not carried out, the ordinance prohibition couldn't be general, but only restrictive, focused on gambles on individual life. On the basis of these arguments, the legal recognition of freedom and repurchase insurance are quoted as an evidence of the initial commentator mistake. Because freedom and life are of quite comparable nature, the justification provided by the initial authors for the prohibition should invalidate freedom insurance mechanism. So the statutory recognition of freedom insurance evidences that the justification given for the prohibition don't reflect the intent of the legislator. Although the introduction of repurchase insurance evidences that the legislator is truly open to judgment on life when they are useful and moral. These two approaches raise a methodological issue. Indeed, they relate the stated legal prohibition of insurances on life and its justification by the initial commentators only with the statutory introduction of freedom and repurchase insurance. They give no consideration to the initial author's comments on freedom and on repurchase insurance. To resolve this methodological problem, the justification of the prohibition should be replaced in the doctrinal context by being related to the comments on freedom and repurchase insurance. Such a view may result in a revisit of the role of the initial authors in a potential transition. In effect, as we have seen in the first point, the text of the ordinance provides a kind of balance between the prohibition of insurance on life and the recognition of freedom and repurchase insurance. And we can note that the article on the prohibition is not set at the beginning of the chapter on insurances. And we can imagine that the most important aspect in the legal text is maybe the recognition of risk of ransom insurances. And maybe the prohibition is not a general principle, but only a limitation of the potential abuse due to an extensive construction of the wording of the article of ransom insurances. The initial commentators may have perceived this. And in any case, if the Article 9, 10, and 11 are reviewed together, the comments of the initial commentators on this article should be considered together. By relating the initial commentators' justification on the prohibition to the comments on freedom and on repurchase insurance, we can constate that the balance of the ordinance is respected. So even if they are moral, or lack substance, or stupid, the justification of the initial commentators on the prohibition of insurances on life are not really an obstacle to the support of freedom and repurchase insurance. So even if they are not affirmatively facilitated the development of modern life insurances, they have not deliberately slowed it down any more than the legislator. To conclude, we can say that there is no evidence on the existence of a transition. But if we take for granted that there was one, whatever its nature, it's impossible to take solely the initial justifications of the prohibition as the evidence of a previous doctrinal reluctance to admit modern life insurances. Thanks for your attention.